Welcome back, everyone. We will now move on to the lunchtime chat on award writing tips and scrutiny of draft awards at SIAC. Our panelists are Mr. Timothy Cooke, Dr. Hop Dang, Ms. Blossom Hing, Director of Jew and Napier, Ms. Delphine Ho, and Ms. Smitha Menon, partner of WongPartnership LLP. Moderating this session is Mr. Minn Naing Oo, Managing Director of Allen & Gledhill, Myanmar Company Limited. A warm welcome for the panelists and our moderator, please.
Very good afternoon, everyone. I hope you've all had a chance to get a bite, or if not, then we will be your lunchtime entertainment. Welcome to this interesting session. You know, when you go through the arbitration process and you go through this long haul of, pleadings, witness statements, and the hearing, and at the end of the day, you get to the award, which is really, the crux of it all, right? And the most important thing to come out of the arbitration. And in order to make sure that you have an award that is enforceable and that will not be challenged, hopefully, if you're the victor, the claimant and the victor, you need an award that will fit the forms of the New York Convention. You will need an award that will be able to clearly set out what the tribunal has decided, and there I think there are many pitfalls that arbitrators can fall into, right? As you prepare the award. We're very lucky here today to have a very eminent list of speakers, panelists, and who comprise arbitration practitioners, arbitrators, and even a couple of registrars. One former one, myself, and of course the current registrar of the SIAC. And Delphine holds a very, very important job of scrutinizing draft awards in order to ensure what I've just said, right? That they adhere to the forms, the legal form, and they are going to be enforceable. So without further ado, we're going to get into this hopefully lively discussion with the panelists, and of course at the end of it, we're going to take questions as well. So please feel free to ask questions, of the panelists, and we'll be very, very happy to engage. So just to kick things off, I'm going to turn to Smitha and ask, what are the formal and procedural requirements of a valid arbitration award?
Thanks, Min. Hi, everyone. So, yes, this is the starting point, and we're really working backwards when we look at this, because from the time you get the award, you need to make sure that it's enforcement proof. It can't be tripped up for procedural reasons, such as the award not having met certain procedural requirements. So if you want to avoid annulment or non-recognition or non-enforcement, you should check the two sources: the legislation at the seat. So what does that arbitration law of that country require for a valid award? And another source you should check is where the arbitration is administered by an institution. You need to check the institution's rules as to what is required for the award. So most institutional rules and national laws pretty much follow what's in the model law. And in the institutional model law, the requirements are quite straightforward. The award has to be in writing. It has to be signed, and it has to set out the reasons upon which the decision was based, unless parties agree that reasons are not required. And these are really just very practical requirements, because the reason for it being in writing is really because in the New York Convention for enforcement, you need to have an authenticated original award or a certified copy of the award. So there has to be something written that can be provided as a certified copy. It's just a very technical requirement, so a foreign court can then go ahead and enforce. There are some other requirements that do come up. Some countries' national laws do require the award to be dated. It also has to be signed by all parties. If it's a model law country, as in a country that has adopted the model law, then you would have to state in the award the place of arbitration. This is quite important because nowadays, arbitration hearings are rarely physically at the seat or awards are also written all over the world because, there's virtual hearings and so on and so forth. So you need to stipulate the place of arbitration in the award, because the effect of that is then the award is deemed to be made at that place. So that's how that requirement is met. In terms of some procedural pitfalls, one that I came across recently was where there was a question if the Chinese court, which is the enforcement court, would recognize an electronic signature on the award. I think it was a Korean award, and the Korean council were very concerned that if they use DocuSign or some other solution that does an electronic signature, would that be enough to satisfy the requirement of a signed award? Or do you need to give a wet ink signature? So these are the sort of procedural things that seem like they're very small in pernickety, but when it comes to enforcement, you'll wish you had paid attention back then. So that's about it.
Thanks, Smitha. I'm just gonna, at this point, ask Delphine, right? So when the SIAC team and led by yourself, and because the registrar has to scrutinize the award under SIAC rules, the draft award. When you scrutinize the award, obviously the points that Smitha has mentioned, you'll be looking out for. But are there sort of any interesting procedural quirks that you might have seen as you've gone through hundreds of awards and you warn arbitrators about?
I mean, there are, so apart from the formal requirements like seat of the arbitration, make sure that you set out the parties' contact details, arbitration agreement on that. There's some other smaller things like if it's 3-member tribunal and each member writes a different part, please format it so that it looks the same, because sometimes it's very distinct when one part A is written by one arbitrator, part B is written by another one. So the whole point is that the final reader, whether or not it's the enforcement court or the losing party, shouldn't be able to figure out that it was written by 3 different people. It has to be written by one. There are some arbitrators who focus on the text, but don't on the actual text, but don't quite focus on how the award looks. Consistency in look and feel also goes towards formality. It goes towards how an enforcement court may view it. A sloppily formatted document which doesn't quite go to the substance of a thing could sway an enforcement court to look at it and say, what is this nonsense? More substantively, I mean, we see now, we see a lot of non-participating respondents. And frequently the non-participating respondents are not so much that they're not aware that proceedings are going on, but they decided, I'm not going to participate. Instead, I'm going to take my chances at enforcement at my jurisdiction. And so what we try to, when we do the scrutiny, we try to preempt some of the potential arguments that a non-participating party may put forward, like I wasn't duly informed of what was happening during the proceedings. So for arbitrators who have non-participating parties, we are quite pesky in that we usually will ask and actually demand that the procedural history is more complete. Make sure that you set out how you were delivering documents to the non-participating respondent, whether or not there were any bounced mails. I mean, deliver, just because you physically sent it off doesn't mean it was received. So things like whether it bounced mails, courier receipts and all that. The whole point is to make it clear in the document itself that any contention that there was insufficient notice is just bollocks from the outset. Other things that we also look at is sometimes we look at language. We get arbitrators from a lot of different jurisdictions, so sometimes the language use may not be as clear. We try to encourage the use of concise language, shorter sentences. I've seen a sentence run a whole A4 page, and it takes a lot of willpower to let that to not correct that directly and to politely ask for it to be fixed. But at the end of the day, I think the guiding principle is this: the award is written for really 2 parties, the enforcement court and the losing party, or rather the losing party first and the enforcement court. Insofar as the losing party is concerned, the whole point of the award is to say, look, your case was bad, okay, you lost, tough, don't try and take this further. If that doesn't work, then the award has to then persuade the enforcement court that this is a non-starter, you should just enforce it, it was all properly done. So really that's the target audience of it. And if you're the winning party, you only care about dispositive, you don't care about anything else, right? So yeah, so that's really the philosophy that we adopt when we're doing scrutiny.
Oh, that's really, really interesting and helpful. And you know, I was just going to follow up with a question. When you mentioned that you now see a lot of cases where the respondent doesn't turn up, right? And so you have to be pesky about, you know, scrutinizing it properly. Does the fact of, you know, where the award might be enforced come into play as well, the jurisdiction?
Yes, it does.
Some jurisdictions may be more arbitration friendly, some may be less.
Exactly. So, I mean, we do see certain, I mean, we know as, ex-practitioner myself, but as practitioners, we know which jurisdictions are more friendly towards enforcement and less friendly. And at the end of the day, where you intend to enforce really also, I think, may influence some of how the procedural history is, for example, set up. I mean, there are other aspects if we are familiar with, like, for example, some jurisdictions require arbitrators to be physically in that jurisdiction to sign off the awards. You can't sit in London and say that you're signing an award in a different place. So those are things that we flag out. Certain jurisdictions will have requirements like you need to execute a power of attorney before you can register the award. That's something that we would typically flag out and say, there's this thing, don't be difficult about it. It's beyond our control. So we try to at least share some of our jurisdictional knowledge. I mean, there's no way to know every single jurisdiction, but we have quite a lot of familiarity with at least Southeast Asia, India to a certain extent, China to a certain extent as well.
Thanks. I mean, that's again very insightful. I'm going to turn to Blossom, and you know, when you sit as an arbitrator, and then you need to write an award at the end of, you know, that long process. What are some of the tips, or what are some of the points that you think, you know, is helpful to bear in mind when writing the award?
Thanks, Min. I will share 3 points. So the first one is the most important, I think. Write clearly and simply in plain language. That means use short sentences. I think Delphine mentioned a 1-page sentence. That's frightening to me. It's like a nightmare. I actually, after I write, I'll ask my team, hey, it's like 4 lines. And if it takes 4 lines of a page, that's too much. You know, it should be 1 or 2 lines. Use direct speech. She killed him on Sunday, not he was killed by her 2 days ago. I think it was Ruth Bader Ginsburg that said, if you can say it in 4 words, why use 5? So 1 word is 1 word too many. And I think that is very true. Each word should count. And it's also the great RBG who said, do the read aloud test. After you've written something, read it aloud. How does it sound to you aloud? And one of the tricks that I use for myself is I ask myself if I've written something which my next door neighbor, who is not a lawyer, can understand. So who did what to whom, and why a certain position is correct or wrong. Explain it in that very direct, pointed way. And I find that it helps me to write and get my point of view across clearly in any communication that I write. So I think that's important. Another reason for an award is, apart from what Delphine said, which is for the enforcing party, for the enforcement court and the losing party, is also for the winning party, because the winning party wants to be able to enforce it. And a clearly written, simply directed award makes it very easy for enforcement, so there's no ambiguity. So I think the first tip is really write simply and clearly. The second tip relates to structure. Either use a chronological kind of structure or a thematic structure, I find. And to make sure that you don't forget the most important points that need to go in, I usually start with just putting in headings first. So I always have 3 headings. The first one is procedural background. You want to make sure that you clearly set out what are the steps that led to the arbitration. Your tribunal is properly constituted. There's due process. If one party doesn't turn up, set out all the efforts that have been taken to contact that party. The second heading, parties' arguments. So you make sure that you set out what party A said, That's actually, to me, the really painful part, because you have to summarize what party A said, and sometimes party A didn't make a lot of sense, and you still have to summarize it in a sensible way, and then summarize what party B said. I think it's important because it makes people understand that all the arguments had been taken into account. So that's the second heading. And the third heading is the most important, of course, is the analysis, where you weigh up the arguments, you weigh up the evidence, and you give reasons for your conclusion. And I think here is where, as arbitrators, we can also be sympathetic to parties and sensitive to them, because this is where the losing party will want to look at it and scrutinize and ask itself, why did I lose? And what I try to do is I write as if the losing party is a dear friend of mine. So I don't make inflammatory remarks to say, like, what a stupid position that is, you know, how can that be right? Or how could you say this to me and make this argument with a straight face? Because it happens, right? But people come and, you know, they want to resolve their dispute. So I try to think of it as a dear friend of mine and write with some respect when it comes to reasons. So that's on structure. My third tip really deals with starting early. I think this might be something that Tim will deal with, but you don't have to wait until the end of evidence taking to start making notes and start writing the points that you want to make. I find that the earlier you do it, the better. And best is at the hearing itself, somebody says something and you say, oh, okay, that's a light bulb moment, you put it down. Then especially if it's a long arbitration, it helps that you've had contemporaneous notes. And I think that really helps in the quality of the award. So my 3 tips: 1 is write clearly, simply in plain language. 2, pay attention to structure, be sensitive to the parties, especially the losing party. And finally, start early.
Thanks very much, Blossom. And you have clearly adhered, you know, to all three tips in presenting your,
your I did
tips.
the read aloud test before.
Yeah, and you obviously had structure. You had 3 points. You articulated each of them very clearly. Simple sentences. So that was wonderful. And you know, I do agree because when I've had to write awards as well, I try to, you know, do some actually all of those things that you've mentioned. And it can be quite painful sometimes when you are wading through, you know, a forest of words and arguments that may not necessarily connect, you know, the parties present, and then try to make sense of it all and put it all together, right, in a form that that at least to you makes sense, and hopefully to the readers of the award makes sense as well. And so I'm going to turn to Tim because this is something that I actually struggle with, you know, when I'm sitting as well. How do you remember, you know, points of evidence and key issues by the time you write the award? And you know, it's something that, you know, I try to do what Blossom says, but I don't always succeed in you know, jotting things down conscientiously, and sometimes I do forget it. So, but I mean, can you share with us your experience?
Yeah, I think that actually a really important part of it is something that Blossom hinted at earlier, which is early preparation. So, you know, if you're, as an arbitrator, come to the hearing and really hearing some of the stuff for the first time, then it is going to be a struggle to absorb it all in one go. Whereas I quite like to, obviously, following the case closely as arbitrators as I go along, but actually I have I start early with a draft award, and I don't necessarily draft things, but I put notes in as I go along. And so as and when something happens, you know, like an interlocutory application or something like that, then I'll put that in my procedural timetable to remind myself I need to go back and deal with that. But often, you know, parties are, and all of us know as acting as counsel, you know, you have case theories that you are putting forward over the course of an arbitration. And you might be laying down, for example, an argument that one party is not going to produce some documents, and you know, you set it up in the course of the whole arbitration, and then at the hearing, you know, you want to be able to present that either in cross-examination or in a submission. And you know, we as counsel, I think we love to put all these things together to craft something we think is compelling. But if the arbitrator hasn't followed it from day one, then it might not have the same sort of impact. So I think it's quite important to follow those stories and to see where the parties are going. It also makes things much, much easier if you're dealing with difficult or multiple interlocutory applications, which I've had a case recently where I had a whole bunch of interlocutory applications, 6 or 7 of them, and all based around pleading points, document production, and so on and so forth. But had I not been following it, it would have been a real headache to sort of try and get up to speed and resolve those in the short space of time that was required. But once it comes to the hearing itself, at least I like to have a framework of where I think the case is going. I'm a big fan of lists of issues, trying to get those lists of issues agreed by the parties early, because you know, parties seldom agree on everything, but I think that they should be able to work together to better say that the tribunal needs to decide whether the answer to this question is A or B. And it's a good exercise to get the parties thinking. And I make it very clear in case management conferences, if I have them, or in interlocutory hearings, that, you know, the list of issues is important for me, because that's what I'm going to be focusing on when I get to the hearing. You know, issue 7, when it, you know, I will my ears will prick up when I know the witness is talking about a particular issue, because I know that's issue 7. So for me, list of issues is important, and going into hearing, I'll have that very much in mind. You know, many people, when they open cases as counsels, they will signpost these things. I think good advocates, you know, will say to the tribunal, look, you're going to hear from Mrs. X on Tuesday, and she's going to be speaking to the issues 2 and 3. And again, that's very helpful. If counsel don't do that, then I try to do it myself and try and work out which bit's where, and I've marked up the witness statement and so on. But the idea of all of that is so that when you get to the end of the hearing, you've got to you remember what people have said, because you know, you've actually gone through the exercise of looking through the statements and and I'll have jotted down notes in my sort of list of issues in the draft award. And then, much to the delight of my family, if I have a hearing ends on a Friday, I spend the Saturday and Sunday going through all of those to make sure all the key points are there, so that if I can start writing the award, I will do. But sometimes, you know, just the way practice is, you don't get to it straight away. If a few days passes, at least I've got that framework and I know exactly what I need to do, and I'm really not filling in the blanks, but I've got a fairly good sense of where the case is going. But I think it's all about preparation, and that's really the key.
Thanks very much, team. Again, you know, very, very helpful tips for arbitrators. You know, just to follow on from what you've said about making a list of issues and, you know, ensuring that you meet them. And I will ask Hob the same, right? When you write the award, do you address each and every issue that comes up, or do you focus on really the main ones, and, you know, for the others, you know, you deal with them maybe together as a whole, and say, well, you know, I've looked at this, and I don't think you know, it goes one way or the other.
Thank you, Min. I think, as a general proposition, I personally would try to deal with all of the issues that have been put up, especially where this is a requirement of certain institutions. I know for a fact that some institutions are very meticulous about this, and they would send you the draft back unless you have dealt with every single issue in some detail, at least, because their view is that at the end of the day, we're all service providers and we've been paid to address these issues, and if we haven't, then we're not worth our fees. I mean, that's their view, apart from other enforcement issues. However, some other jurisdictional institutions are more flexible, and there are some cases where you know, some of the issues that really either unnecessary or just don't even make sense, you know, somehow, but they've been put up in any event, and it would be very awkward to have to deal with it, and would make the award look somewhat out of shape in a way, I have to say, in some of the cases. So in those situations, it's a bit of a judgment call as to how to strike a balance between addressing all of the issues and then on the one hand, on the other hand, you know, making sure that the award is, you know, read nicely and ensures sufficient substance for enforcement in the future. So the answer is it varies from case to case. So,
but, you know, okay, so if you have to address every issue and, you know, maybe write a a very long award, how do you then ensure that you keep to the timeline set by the rules and ensure that the award is issued on punctually?
Yes, and thank you. I mean, one more thing about all of the issue is that, of course, you have to deal with all of these substantive issues. But one thing I've seen sometimes not dealt with as appropriately is issues that are raised and dealt with in the procedural meetings. When you don't have a transcript and proper notes and things like that. But sometimes important decisions are made in these meetings, like a joint application, for example, discovery and stuff like that. And sometimes that's a pitfall. The enforcement court might say that, you deny the adjournment. What are the reasons? Why did you deny the adjournment when the counsel was sick in the hospital or something like that, whatever the reason was. So I would advise tribunal members to pay special attention to these even procedural issues and not just deal with them slightly for the sake of it, but really be very careful there. In terms of the timing, again, as what Tim and I think Blossom or others were saying, that you want to start early, even with notes, but I would even go further. When we set out the timetable in the procedural conference, in the case management conference at the start, I will try to ensure that I at least have 2 or 3 weeks, if luxury allows me, between the conclusion of all the submission and the hearing time. I know we have other commitments, especially if you're in legal practice, you get called away at short notice, but at least I've got some luxury of time there to prepare, at least for myself, a full award with question marks and blanks in between. In an ideal scenario, I can also share that draft award with the other tribunal members as well for their comments, if any. But at least I've got to have that for myself. I would not want to be in a situation where I finish the hearing, I go away, I draft the award, I say, oh my God, I didn't ask that question. How on earth would you then deal with the issue, because you can't call the parties back, and you forgot to ask the most important question. And so you really have to start early, as people have said, trying to get in my view, a full award before the hearing, and you're in the perfect position just to go through the hearing. And going back to what Tim was saying about taking notes of issue, if you've got that draft award in front of you, you don't need to take a lot of notes because it's there already. You just fill out the blanks, fill out the question marks, and by the end of the hearing, then again, going back to the procedural timetable, I try to allow myself, a few days just to turn that off, finish that off, even if just for myself. Sometimes I do it for myself because another person in the tribunal is charged with drafting actual award. That's fine, no problem. I mean, it may be a duplication and waste of time in some people's view, but if at least for my purposes, I've got a nice product sitting there, so I can go back and use that when I review the draft award made by the chairman or someone else, which I find very, very helpful as well. So again, in summary, the point is to start early, be comprehensive, and finish early, and that'll take a lot of pressure off you in due course.
Hey, thanks very much, Hop. I've gone through this exercise myself, listing issues and trying to work them through. But sometimes, parties, no matter how you prepare, right? Issues come up during the hearing, and even when they're supposed to be an expedited procedure case, you do get more issues than I think you would have bargained for at the beginning, when you thought, okay, this is fairly straightforward, and then you have very strict timelines, and it becomes a challenge, right? So it's helpful to know how then you can plan and try to meet those challenges ahead of time. So Delphine, I have a question for the registrar. When it comes to expedited procedure cases, and you're able to provide a summary award form, right? How do you scrutinize those awards in the same way, or how do you treat them? You're on mute, Delphine.
Damn it. Okay, so hopefully I'm off mute right now. We scrutinize EP awards in the same way. The only thing I guess that really happens is that we would prioritize an EP award. The process of scrutiny really doesn't change as much. We do get slightly more pesky with the tribunal in an EP situation. We will start sending polite reminders about 3-4 weeks before that. Please give us at least 10 to 14 days to complete the scrutiny and the cost determination process. Because while I will determine the cost, it still has to run through the SIAC's finance side to get the final figures churned out, the expenses, any GST and all that stuff. So that process takes time. Just to share, the SIAC's scrutiny process is really a 2-level process. So each SIAC case is handled by a case counsel. Case counsel will do the first line of scrutiny, which includes going into minutiae, such as even to the extent of checking footnotes, making sure, we've even done things like make sure that the case that's cited is actually the correct case, because we've seen mistakes made there. We check quotes, we also check the pleadings and all that stuff. So really, case counsel are expected to be familiar with the case that they are handling in order to do the scrutiny. So they do a micro review. Then it comes to me and Kevin, we tend to do a more macro review. We don't typically go through the documents. The logic behind the process is if for someone like me, I've never read through the base documents. It's not a case that I'm immediately familiar with. If I can't understand the award, that's a problem, because then whoever your enforcement court is or your parties, they may not understand the award. So that's something that we will try and work with the tribunal on. So same process applies even in an EP situation.
Okay. What about the emergency arbitrators' decisions?
Exactly the same. We will also scrutinize. Again, so in terms of priority, EAs come first, followed by EPs, and then regular timelines. For EAs, sometimes because of the time constraints that come in together with an EA decision, we may do a concurrent scrutiny. So counsel may do their scrutiny while I'm doing another one. We may do a part scrutiny. We'll do the scrutiny of the procedural history first, leaving the dispositive and the analysis to when it's decided. But whatever it is, so far, I think the longest EA decision I've seen is maybe 80 pages. Doesn't get to the point of a regular award where we're looking at hundreds of pages. So hopefully we'll never get to that point, but who knows? But yeah, exactly the same, doesn't change. We don't shortcut the process or short circuit the process just because it's an EA or EP. But
for an EP case, do you see a tribunal submitting summary awards in summary form?
Yes, we do. But I think the distinction. Yeah, but the distinction between a summary award and a full award sometimes is really not that strong. I think with an EP, generally things like procedural histories and narratives are shorter simply because the case itself is not as complicated. The number of interlocutories may not be as many. So naturally, certain parts of the award would be more compact. But other than that, I mean, the other part that I see more truncated in EP awards would be things like narrative or the recitation of parties' respective submissions, like what Bloss was saying, where sometimes you try and requote or you try and set out what each party has said in relation to a specific issue. That section may be a bit truncated as well, because Blossom is right, that is one of the hardest sections to write, because you don't really want to over summarize, because when you over summarize, you might not actually be catching the argument. You might make an argument sound smarter or stupider than it actually is.
Thanks, Delphine. I can't agree more. Smitha, I'm just going to ask whether, in your experience, you've seen the use of tribunal secretaries as being fairly common or not so much?
Yeah, no, it's very common. And after the UCOS, so basically this whole controversy over tribunal secretaries came up really because of the UCOS award. So I mean, just for the benefit of those listening, so in the UCOS award, it was a $50 billion award against a UCOS, a Russian entity. And what happened was Russia tried to set aside the award before the Hague Court. And one of the grounds on which they sought to set it aside was that they said there was actually a fourth arbitrator who helped write the award, and that was the tribunal secretary. And so in doing so, the tribunal sort of did not fulfill their mandate and sort of ceded decision-making powers to the tribunal secretary. Even though this ground was not the reason the award was set aside, it did shock and scare people, because tribunal secretaries are fairly prevalent and fairly common in arbitrations. And so after that, everyone started worrying about, okay, what exactly is the role of the tribunal secretary? When does the tribunal secretary actually become the hidden fourth arbitrator? And I've noticed that different institutions have also come up with rules to try and sort of regulate around this. So I know for SIAC, the 2015 practice note does require all parties to consent before a tribunal secretary can be appointed. In some other institutions, they do actually set out whether the tribunal secretary can even draft parts of the award. So I think it's, hang on, where's my notes? I think for the Australian institution, the AKICA, they allow so in the Australian Centre for International Commercial Arbitration, they've got guidelines on the use of tribunal secretaries, so beyond appointment. And there they actually allow the tribunal secretary to be involved in drafting the non-dispositive sections of the award. But as a countermeasure to that, they actually do have required the parties to have a say in the tribunal secretary. So I think for under the AKICA guidelines, you do need to send the resume of the secretary to all the parties, and the parties need to agree. Whereas for LCIA, HKIAC, the decision is still that of the tribunals, but you need to let the parties know. So generally, when you take a step back, I don't see a problem. I don't think there should be a hard and fast rule that the tribunal secretary should only, book hearing rooms, help with the research, do the formatting. I see the sense in having the tribunal secretary as a personal aid to the tribunal in sort of making sure that the person who's the most familiar with all the documents, at least at the early stages, is pointing out to the tribunal, okay, you are looking at this point, look at, these are all the documents at this point. As to helping with the drafting, I also don't see a problem with that, because I don't think that just because you've helped with the drafting, it necessarily means the decision has been made by you as opposed to the tribunal. But I think where it was said very well was this English High Court decision of P and Q, which is quite interesting because that is the kind of lawyer's nightmare type decision. Because what happened in that case was that the chairperson of the tribunal accidentally emailed the claimant's lawyers when he meant to email his tribunal secretary, asking the tribunal secretary, hey, what's your views on whether the claimant has complied with the document production order? And so this accidentally went to the claimant's lawyers, and they immediately tried to remove the arbitrator by saying that, look, he's like passed on his decision-making mandate to, well, the court, I actually have it from the case. What they alleged was the arbitrators effectively passed their pens to the tribunal secretary. So they tried to set it aside. And apart from this email, they also relied on other things like the length of time the tribunal secretary had spent on the arbitration. And unfortunately, the tribunal secretary had recorded more time than any of the tribunal members. And also the fact that most of the hours recorded were after the hearing. So it must have been in relation to preparation of the award. So this is an LCIA administered arbitration, and the LCIA court, they heard the complaint and they dismissed it. But when it went before the High Court, I thought the High Court put it very well. I mean, they felt that they should be slow to differ from the LCIA court's decision, and so they followed it. But they also made this comment. They said that, they ran through all the commentary that's been published by institutions and academics and commentators on the role of the secretary. And this is the conclusion they reached. The High Court judge said, a tribunal secretary may, if properly supervised, undertake legal research and draft portions of the award. An arbitrator who receives the views of a tribunal secretary does not thereby necessarily lose the ability to exercise full and independent judgment on the issue in question. So I feel that the court was really being very, not deferential, but emphasizing the high degree of discretion that tribunals have, and also showing that the arbitral process, if it's a robust one, then we shouldn't be so quick to shut it down just because the tribunal secretary may have written parts of the award. For myself personally, I'm involved in the scrutinizing of the ICC awards, and I can tell you that one thing that does come up that gives court members cause for concern when scrutinizing awards, especially midway through the process. So when you're looking at a award of jurisdiction, for example, is when the numbers recorded, the hours recorded, really show the tribunal secretary has spent a disproportionate amount of time on the case as compared to the arbitrator. Sometimes it looks really bad. It's like a co-arbitrator will clock 40 minutes and the tribunal secretary will have 60 hours. It's just a bit well, so what I've seen the institution will do is will just sort of like make bring to the tribunal's attention, hey, you know, do you realize there's this sort of disparity in the time spent on the arbitral process? So just, you know, sort of hint, like do your job and not so many words.
Yeah, thanks, Smitha, for that. You know, and I think you know we have some time for questions, but just before that, I'm curious to hear from the other panelists on this cross-cultural question that that I have, which is there a difference in working between with civil law arbitrators or civil law background arbitrators and common law background arbitrators? I mean, I'm throwing it open to, you know, to everyone, and if you could just very quickly, you know, give your views, I think it would be interesting.
Yes, I mean, I'll start off and then others may add as required. But before I touch on this question, can I just finish up one quick point on the drafting of the award, which is that I've seen, I think tribunal members owe a duty to treat the parties equally. That's nothing new. But sometime in the award, I think it's unintentional, but sometimes I've seen awards making a complete references to either the arguments or even just the procedural actions of one particular party, but for whatever reason, failing to describe in full either the position or even just the procedural actions of the other party. And I think that should be avoided, because a fresh reader reading the award may just get the perception, again, you know, unjustified, but just get the perception that the tribunal is not treating the parties equally. Now we're going back to your question about the different differences in working with tribunal members from different backgrounds. Yes, I have worked with arbitrators from both common law and civil law backgrounds, and I think there's a noticeable difference in the draft award that I get back from each of them. There's clearly, you can sort of just read them and you know who has drafted the award, and in the sense that the common law arbitrator will quickly go into the you know, the arguments, how to apply the law to the facts, and a lot of the time assuming that the law is undisputed. I mean, a lot of the cases the law is undisputed and doesn't need to be described again, and just how you apply the law to the facts. On the other hand, if you go to a word drafted by a civil law arbitrator, there's a lot of emphasis on describing the background, you know, even the law, sometimes even the legislative history, why the law was enacted in the first place, and all that. And then less emphasis on how the law is applied to the actual issue at hand, and rather sort of with that big background in mind, then if you've got this issue, the outcome's got to be this. So I think if I get such a word, I tell myself to try to adapt to, rather than just simply imposing my own view on how it should be written, but try to adapt to the different perspective of different people from different backgrounds, and try to sort of supplement my own input in order to make it a more balanced word. And going back to what Delphine was saying, that, you know, no one's going to know who's written the award. You know, oh, it certainly looks like a civil law lawyer, so there's got to be this particular person being the main author. No, I think at the end of the day, if you deal with it carefully enough, you'll come out with a very balanced product, reflecting the views, the traditions, the thinking of all the tribunal members, whether they come from civil law or common law background. I think actually I much prefer that rather than having just an award written by all three common law lawyers or civil lawyers. Thank you, Min.
Thanks, Hob. Blossom or Tim?
I think my experience is quite similar actually to what Hob says in terms of what the focus of the award is. And I think you see it also, I've seen it also from the perspective of account as well, looking at award and seeing, you know, there's been an emphasis on maybe and understandably, like the legislative history of a particular provision, particularly if you're, and it would depend actually on what law is governing the dispute as well. Because if you've got a civil law, a Vietnamese law applying the dispute, and like me, you're a common law lawyer and you're arguing those points, with your help from Vietnamese counsel, it's not going to be very surprising that the award that's written is going to have a different sort of focus than if a common law lawyer approaches it. But you do see definite styles in I think the way they're put together. And I think the idea is to make sure that still it comes across as a cohesive product.
And I'll let Blossom have the last word.
So I agree with what both members have said, but the other thing I find is different between civil and common law is the tribunal or the arbitrator itself in different jurisdictions tend to interject themselves differently in the arbitration as well, in the process of it. So not just in the award writing. I've seen a couple of common law lawyers, and these tend to be, your very experienced lawyers when it comes to sometimes the cross-examination. They get involved and start asking the questions, probably in a better way than what they perceive to be going on in the proceeding itself. The civil lawyers, civil law arbitrators, either they kind of go right in and ask about the what the background of the law is, or they actually just, a lot of times just let the parties go on and do their own thing. That's been my experience. I haven't had that many arbitrations where a civil law lawyer or a civil law person is an arbitrator, but during the course of the one that I did, that was my observation.
Thanks very much. We've got about 15 minutes left. So are there questions from the floor? I was trying to look at the Q&A button, but I don't see any written questions coming in. But please feel free to ask. Yes, we have a question. After EA is granted for interim order, if the claimant wants to maintain the said interim order, should the claimant resubmit the application to the tribunal of the main proceedings? So this is in an emergency arbitration, and you've got an interim order. Should the claimant resubmit the application to the main tribunal when the main proceedings commence? I think that's the question. Delphine, you want to give the SIAC a view?
This is clearly not an award-related question. Give me a moment while I pull out the rules, because I'm fairly certain this is directly dealt with in the rules. So it says, if you take a look at the schedule, give me a sec, Mike. I'm having a very bad set of computer connectivity and internet problems today. Give me a moment. So it says that the tribunal can reconsider, modify, or this is paragraph 10 of Schedule 1. Tribunal may reconsider, modify, or vacate any interim order. Tribunal is not bound. Any interim order or award issued by the emergency arbitrator shall in any event cease to be binding if the tribunal is not constituted within 90 days of such order or award, or when the tribunal makes a final order or the claim is withdrawn. So if the tribunal is constituted within the 90 days, the interim order would stand. So you don't really have to reapply for the interim order. That's it. I wouldn't be surprised if the counterparty would be applying to vacate or vary the interim order. So,
yeah, maybe just to add on to that, yes, I think that once an EA has made an order or award, and then typically that would remain in force and effect. And of course, the tribunal that is then constituted afterwards, by reference to the provision that Delphine just mentioned, effectively has oversight over that award or order. I mean, they won't tend to interfere unless the parties make an application. So typically they will just stand, but you will get occasions where there'll be a renewal for an application or for one party to ask for it to be vacated for a particular reason, and that will then be just dealt with by the main tribunal. But unless that 90-day time period has elapsed, then the award stands. But that is that 90-day period is something to really watch out for as counsel, because sometimes the appointment of the tribunal takes longer, and it can be difficult It's not that you know, anyone drops the ball, but it can take time for a three-person tribunal to be appointed. And as the claimant, particularly, and if you've got an EA award in your favour, you need to watch that time limit very clearly. Otherwise, you do have to apply back to the tribunal if that 90-day period has elapsed and ask for the effectively the terms of that award to be renewed, and you may have to re-argue the application.
The Secretariat gets a bit NC as well. So because we take the position that we operate to a certain extent like a law firm, in the sense that we're not going to move and constitute the tribunal unless there are funds to account. So if you don't provide us with funds, we're not going to appoint the co-arbitrators, and in which case all the arbitrators in the tribunal is not going to be constituted. So if parties who have obtained an EA order then start getting pesky little comments or emails from the SIAC Secretariat saying, can you please pay their deposits? That's usually a hint there's usually a hint there, which is, can you please do something about this before your EA order lapses?
Right. Thanks both. We've got another question. It says, can disputes in common law jurisdictions be heard in common law seat? I wonder if it's supposed to read, you know, can disputes in a civil law or common law jurisdiction be heard in a different type of seat, whether if it's a civil law jurisdiction case in a common law seat and vice versa.
I mean, I can start this off first. At the end of the day, the choice of the seat is really a reflection of your choice of the supervisory court. So it is entirely possible for a dispute with the underlying contract governed by Vietnamese law. Hop, I'm sorry, that's the best example I can give since you're right in the screen in front of me. So a Vietnamese governing law contract can be arbitrated in Singapore with a Singapore seat. I mean, there's nothing wrong with it. There may be strategic reasons that parties may want to choose a particular seat. There may be, like, say you're talking about you want an arbitration friendly jurisdiction because your enforcement is going to be in that jurisdiction. But really, at least in principle for that question that was asked, there's really nothing wrong with choosing a common law seat, civil law, governing law. You could well have the arbitration agreement governed by one law, the contract governed by another, and so on and so forth. It's really about party autonomy and your choices. That's it. When your system of governing laws for your arbitration becomes more complex, you potentially open yourselves up to different lines of attack at the point of time where you're actually in the arbitration. So I tend to tell, when I teach drafting classes, I tend to tell the participants, it's best not to be too smart about the governing law. It may sound good at the point of time you're drafting, but it creates a lot of problems later on.
Yeah, that's definitely useful advice. And anybody else wants to add anything to what Delphine has said?
I would just say it happens all the time. Plenty of cases are seated in Singapore and the substantive law is Vietnamese law, Myanmar law, Cambodian law. I'm sure it's part of SI's success and to attract that sort of work and have it seated in Singapore.
Yeah, exactly. We've got another question, which is, have you ever encountered, and when you make many suggestions during scrutiny and the arbitrators accuse the court, I assume the secretariat or the registrar trying to intervene or making influences towards the award? If so, how do you deal with it?
Min, you should answer this first, because I have a particular perspective on these things.
Well, in my time at SIAC, maybe the arbitrators were not so indignant when we made lots of suggestions to the awards. At least in my experience, I mean, in general, the arbitrators were generally were happy that the registrar and the secretariat would scrutinize the awards and make those suggestions, because they've gone through this at least a few times, right? And by the time to the draft that's sent to the SIAC, they may think it's perfect, but of course, because they've been looking at it for a long time, you do spot things, and sometimes very obvious ones, like the date or the place. And it's not because they've forgotten, that it was deliberate or these are not experienced people. It's just that, they are concentrating on the substance and the analysis and the disposition of the award. So in general, I find the arbitrators are appreciative of the scrutiny, and really because I think at the end of the day, the tribunals want their awards to be enforceable, right? They don't want it to be set aside on some procedural ground. So they do appreciate that. I found. Yeah. You please offer your
So I would say that in 95% of the cases, tribunals are actually quite happy with the scrutiny process. There may be sometimes it takes a bit longer because the award is long, but overall I think there is some satisfaction with the process. Min, you're right in that an arbitrator, anyone, I mean, if you're anyone who writes submissions, or even if you're an academic, you're writing papers, after you read it for like the 15th, 20th, 25th, 80th time, you can't spot anything anymore. The error might be staring you in the face. You still wouldn't see it. So having a neutral party like SIAC read through it afresh actually helps to sanity check certain things. I think that there are a handful of arbitrators who openly declare that they will never take on board any scrutiny comments. I'm like, tough, okay, that's your choice. Okay, I really, I think the way I approach it is we highlight these issues because we see this as a gap that could be addressed. But as long as the tribunal addresses his or her mind to it and says, okay, fine, I read this, I don't agree with it, I'm not taking on board the comment, that's fine and good. At the end of the day, the prerogative is for the tribunal to decide. I mean, we've caught some really, really potentially disastrous errors. Like we had one case where the tribunal found that the contract upon which the arbitration had been initiated was void. So on a jurisdiction standpoint, they took the position that they had no jurisdiction. But then immediately after finding there was no jurisdiction, they continued with the rest of the award by essentially giving directions for the rest of the conduct of the proceedings. So I was like, hang on a second, this doesn't make any sense. So he flagged it out to the tribunal. It was a fairly eminent tribunal, if I remember correctly. And it's just things like this now that mistakes can be made. It doesn't quite matter how senior or how experienced you are. I mean, we're all human. I mean, some may prefer to think that they're not, or at least that they're superhuman. And I think we've learned in the SIC Secretariat that it is part of the work that we do is also about managing the arbitrators. So we don't say, if we highlight something, we don't say, hey, you made a mistake here. We would say something along the lines of, tribunal, we may wish to reconsider this particular sentence because the meaning that you're trying to put across is not clear. I mean, you have to be quite churlish to be angry at that kind of comments Okay.
No, I agree. It's managing arbitrators is it's a challenge all in itself. That I'm sure we can all talk about.
It helps if you have experience managing senior partners.
Yes, I agree. And there are lots of senior people in the arbitration circles. So maybe one last question. Otherwise, we are about on time.
Can I just make a final point, Min, if there is 1 minute left, just in relation to drafting of the award. I've had recent experience of tribunal members suggesting to me that when you capture the party's position, there's no better way than simply copying and pasting the submissions of the party and put them into the award, because we shouldn't be revising them, because what doesn't matter what you do, you can't replicate 100% of the arguments. Personally, I would suggest against that, because my view is that unless you're able to, with confidence, describe the party's position, then we have not done our job. You have not understood them fully. That's number one. Number two, with due respect, some of the positions are not put in the best way possible. And you really have to put them in a different way, if not better. And thirdly, parties wrote their argument with a different objective in mind, obviously. And so there are a lot of nuances and differences. And I think it would be, in my view, ill-advised to simply copying and pasting that into the award. You would be very, very careful.
Yeah, I just say I completely agree with that. And I think that from the perspective of a party as well, when a party reads an award, which is the respective cutting and pasting of arguments, it does not instill you with confidence that they've really thought about the issues, because, as you rightly say, those those arguments are drafted with a particular aim in mind, but it's not really always the best way to articulate what has been put. And there's no better way to understand the party's case than to try and simplify it. And I think as your job as arbitrator is absolutely to do that. I completely agree with you.
Agreed. I think on that note, you know, unless anybody else has a last call of wisdom to share, we can probably close the session. Yeah. Thank you very much, everybody, and for sharing your insights, and thanks to all the participants who came on and listened and asked questions. I hope you know, it was a very useful session for you all. Thank you.
Thank you all for the interesting discussion.